Hello, friends. Are we going? Okay, great. Good morning. Happy June 14th, 2026. It's 10:30 a.m. here in Omaha, Nebraska. My dog Ziggy here is trying to play fetch with me. Here we go. Ziggy. Um, it's story day. I have a second story. If you missed episode 1, it was the Daryl Parker wrongful conviction live stream. And I posted that, I don't know, maybe 2 weeks ago. If you like true crime, it's true, and there was a crime, so you should like this. And it also kind of gives you a little bit deeper insight into my background. I'm an attorney. The Daryl Parker case was one of the first cases I ever worked on, ever. And that's while I was in law school, started around 2010 and into 2011. And this is a case, today's case is from the same time frame. It is called the Daniel Retz versus William Seaton case. And it's not a wrongful conviction case, it's a civil rights case, and it involves the Fourth Amendment, the right against unreasonable searches and seizure, sometimes known as excessive force. And so we were representing the plaintiff. This, when I joined in the case, probably around late 2010, maybe. It was still pretty early on. We were doing fact gathering. This is a case brought against the Omaha Police Department. And we'll talk about how this is another extremely rare result. So in the prior case, Daryl Parker talked about how this is like a 50-plus year journey into obtaining justice after he was wrongfully convicted in 1956 for unaliving his wife. And it was a super long journey, but after Nebraska passed the Wrongful Conviction Act, maybe somewhere around 2009 or so, Daryl Parker was one of the first people to recover under the act, and he got the full statutory maximum of $500,000 and a public apology from the Nebraska Attorney General. And that was a case that I worked on, and the more details are in the prior stream. So, okay, it'll be another story time, like I said today. Hope everyone's having a good weekend. The last stream I did at my office, and now I'm here at my apartment in Omaha, and Ziggy's here. And I'm still new to live streaming. I mean, this is my second one. I don't really know the ins and outs. I guess if people were actually here chatting, I would need like a moderator or something. But I think one person viewed my last stream while it was going, while it was actually live. And we'll see if anyone joins us today. Another point I want to note is, as I've said before, I will sing for money. This is one of my policies here at New Joel is I will sing for money. It has to be a song I know. Sometimes lyrics are hard and I can kind of know the sound of the song, but I'd have to like fake the actual words. So it's better if I know the words and the details. And I would say some of those songs are like bands of songs that I might know and sing would be Journey, Queen, the Beatles, maybe even Lady Gaga, Britney Spears, 311, Incubus, Tenacious D, Black Eyed. No. I was going to say the Black Keys, but I guess the Black Eyed Keys have some good ones too. Linkin Park. Maybe Nirvana. I don't know. Foo Fighters, Red Hot Chili Peppers, Led Zeppelin, Dave Matthews Band. So those are a decent start. Amy Winehouse, Rihanna, maybe see a Lonely Island. Love the Lonely Island. Just tell me what song you want to hear. I'll sing it, but I will do it for money. That's the deal. And I will stick to it. So, okay, here we go. Let's transition. We're going into true crime live stream number 2. This is the case of Retz versus Seaton in Omaha, Nebraska. He was rude. He was angry. He showed up in a parking lot in Omaha about 3 a.m., upset about a stolen car, upset about his ex-girlfriend, upset at the police, not really helping himself, not doing himself any favors. He made a gesture. He mouthed profanity and acted like the kind of person the jury may not be too sympathetic about, may not really want to help him out of this pickle that he's put himself into. But a federal jury in Omaha nonetheless found that an Omaha police officer violated his constitutional rights anyways. That's the story of Retz versus Seaton. It's not a story about a perfect plaintiff. It's not a story about a good guy versus a bad guy. It is about the minimum floor of human decency that constitutional is supposed to give to people, to bless all the citizens with these minimum protections. Doesn't matter if you're a good guy or a bad guy. As long as you are in society, there is a floor about the basically what you are required to be treated, like a level of respect and dignity. There is a bottom level that you can't go below. And that is what this case is about. It's civil rights like this, the right to be free from unreasonable searches and seizures. It's not a prize. You don't have to earn it by being nice. It's not a reward for people who are really resilient and can overcome obstacles and persevere. Like I said, it's just the minimum, and it applies to people that you don't like and don't probably have the patience for, and you wouldn't act like they would, and you wouldn't tell other people to act like they would. But there is a bare minimum, and the government is not supposed to go beyond the bare minimum. And so, as I said, my name's Joel Fulton. Hello, friends. I'm a lawyer, but I also am a creative soul and artist. And hopefully you've been following me along with me on my YouTube channel. Originally, it was titled Peace in America. And I had some good, fun episodes about that. And I introduced you to my dog, Ziggy. He's an Australian Shepherd, and he's 5, and he's a good boy. And one of the things about Australian Shepherds is they don't have 4 feet. They have 2 feet and 2 hands, just like you. So remember that next time you say 4-legged friend. It's actually 2 feet and 2 paws, aka hands. Okay? So let's remember that. And before I was a lawyer, I was a law student at the University of Nebraska College of Law. I already talked about during that time. You start in your second year, they call it the 2L year. You're allowed to do some work outside of school about 10 hours a week. So you don't just do class, but you go out into the world and do some practical things in real cases. And you do it under the supervision of a licensed attorney. They call it being senior certified, meaning I applied, and it's a pretty common thing that the school encourages is let's get these people some real experience. So before I had my own license and passed the bar exam, during law school, you are allowed to work on real cases. And this was a real case, and I was the second chair at trial. It was a 3-day jury trial in Omaha Federal District Court, Nebraska. And last week you heard about the Retz case. This is the Daryl Parker case. This is the Daniel Retz case. The Daryl Parker case was about historical injustice, and we got into the Arizona versus Miranda decision and custodial interrogation and why there is a right to remain silent and why people who are innocent of crimes might confess, because there is a psychological playbook. And we talked about before, the earlier tactic was just to literally beat someone up and get them to confess just by beating them up. And then it evolved into psychological tactics, playing kind of mind games and really wearing down the defenses of someone who is innocent, but they just end up confessing to get out of that situation because it's so stressful and confusing. And they would never expect that one decision, since they are innocent, that just saying something would put them on the track to being guilty. But that was the point of getting the confession, is once it's out, there's the argument that innocent people don't confess. Why would they confess if they didn't do it? And there was a victim, and so we need to have a sacrificial lamb here, and we do know that they confess, so case closed. That's kind of the thinking behind it. This is a different situation, but it is about, it touches on law enforcement, like Daryl Parker did with the prosecution and the coerced confession, custodial interrogation. This case, one thing that makes a difference is it was modern day. It happened around 2008, 2009, or something like that, when the events actually happened. And there was, while I was in law school, we both did depositions of the officers involved. I think there were 3, and then we had a 3-day jury trial. So this is what I learned, is that when you're really trying to analyze this stuff, Fourth Amendment cases, unreasonable search and seizure or excessive force, you have to slow things down like the Matrix and bullet time to actually accurately analyze this sort of event. And to see what I mean, I'll give you an example, but there is a right way to analyze these cases, and you really have to slow things down moment by moment, because these are usually chaotic scenes. There's a lot going involved, and if you just watch what happened, you wouldn't know what to think, really. There's so much going on. So that's why you need to slow things down, and there's certain guideposts and recurrent themes that you look for and learn for over and over again, but you do need to slow things down. That's where the constitutional boundaries are, is bullet time, where seconds are the difference between life and death. And there's more, even 1 second is kind of long sometimes for different things that can happen in the context of an unreasonable seizure. So here, that was the intro. Here's chapter 1, titled Law School, Daryl Parker and the Education I Did Not Expect. And we've talked about it already, but if you watch the Daryl Parker scene, you'll know that during law school, I was getting close to real cases with real human consequences. And roughly at the same period, I was also working on this case, which was a constitutional rights case. There's a federal statute called Section 1983. And under that law, we brought an excessive force claim against an Omaha police officer. One of the cases is under Section 1983 in the Fourth Amendment is Graham versus Connor. It talks about objective reasonableness. And I will try to give you examples of that, but a lot of it focuses on um, an awareness of different factors that are going on in the moment, in real time, in the moment, not hindsight. That's a key. It has to be known in advance. But there's different things that might carry different importance, like safety risks, alternative measures, exigency, things like that. Um, so one of the things we did, there was an internal affairs investigation for this case. I'm about to get into the facts, but we were able to compare the officers' statements that they made to internal affairs with their later deposition testimony. And that gave us the facts, what the scene was. This is a parking lot at 3 a.m. Where were the different cars? What could people see? What was the lighting like? Had Mr. Retz already been searched? So, or had that not been done and needed to happen? Was anyone armed? Were things in general escalating, or were they more winding down? And you want to go at that process in slow motion. And that's the challenge, is you have to make yourself do it, and you won't understand why until you try. And then it is fascinating that you start seeing and understanding the issues and elements once you actually slow things down. And your legal analysis becomes frame by frame, moment by moment, second by second, and you're applying the same test to those moments about what I called objective reasonableness. It's supposed to be your average police officer or law enforcement personnel in this situation, knowing what they know and are aware of. What are the options that they have? What are their risks? And it's not supposed to be based on this specific officer. If their name was John Smith, for example, it's not supposed to be too much about what they call subjective factors. It's just because you want it to be a predictable, and you want it to be a standard of wide application to the best that you can. So you don't want an officer by officer rule. You consider things the officer knew, but the rule is just based on your average officer. And was this above? Maybe this wasn't perfect, but was it average or so? Or was there a clear violation of this floor that we've been talking about? Chapter 2, the ugly 3 a.m. facts. So now I've gotten to the facts, and here's the basic background story. Daniel Retz, he had reported his car stolen, and 9 days later, the car was found in Omaha in a parking lot, and his ex-girlfriend, Emily Kofel, was with the vehicle when it was found, and officers from the Omaha Police Department responded to the scene. Retz, when he arrived, he was angry and agitated. He was really ticked off and annoyed. He was not a calm, serene guy, and he wasn't really put together and polished. He wasn't your ideal candidate for the kind of best version of a plaintiff that you could plug in and try to win a civil rights lawsuit. He wasn't anything like that. It was kind of known as a domestic situation somewhat. They were boyfriend, girlfriend, and they are clearly arguing, and Retz had thought that his girlfriend had stolen his car for 9 days. It's the basic background. And so officers know that domestic situations are more dangerous than your average situation. They're really volatile. People make bad decisions, and they're angry, and so they need to be, so that this type of scene needs to be secured. Usually the people need to be separated, and there's a whole protocol for dealing with the domestic situation on scene. So it's pretty much under control now. Like Retz is there, the girlfriend was there, and there's 3 officers there. The girlfriend was in one of the cars, and Retz had been patted down. But then he decided to walk in front of the cruiser where his girlfriend was seated, and he gave her the birdie and mouthed the F word to her. So Officer William Seaton arrested Daniel Retz for disorderly conduct. So then that's where we slow things down and we get to the constitutional moment, because yeah, that seems really lame off the bat that the officer would impose his will and arrest someone who had his car stolen and everything. But that's by itself probably wouldn't be any sort of claim whatsoever. An arrest like for something like disorderly conduct captures all kinds of various ambiguous conduct. I'm not a criminal lawyer, but I would guess that it's some kind of misdemeanor and it would be a really small punishment, but it's still, you would still be arrested and I don't know, I guess taken into custody for being disorderly. Here's the important facts. So it's not that he was being disorderly. That's kind of where the officer interjected. But here's what is important is Retz, he had just recently undergone rotator cuff surgery. And he testified that when Officer Seaton moved to place handcuffs on Retz behind his back, Retz told him he couldn't put his right arm back because he had just had surgery. And Retz testified that Officer Seaton responded, "I don't care. I'll show you how far it will go back." That was his testimony. So Retz said that the officer forced the arm behind his back to handcuff him, and that's when he basically ruined his rotator cuff surgery that had just been repaired. It was re-injured. And Officer Seaton denied, basically what it sounds like, what you would say notice, I guess, is did he know that, did the officer know in time before he handcuffed Retz that he was injured? That's a classic case of he said, and the jury saw both witnesses, and they, even though Mr. Retz is not the best witness, the jury still had to decide who was more credible, who did they believe, or like maybe they believe them both, but what is the tiebreaker? Who is more credible on the details that matter? And so it wasn't about whether you like Daniel Retz. You probably don't. He was not the best role model, but if he's being rude and flipping people off, is that a reason to use force when it was used with notice? According to Mr. Retz, the officer knew that he had just had surgery on his right shoulder and therefore could not be cuffed in the back. He could have been cuffed in the front. This is pretty much the main claim. And there's also a theme in the law, and we'll move on to chapter 3, the imperfect plaintiff problem. And it reminds me of what you sometimes hear in the First Amendment free speech context is the free speech right is really most tested and most important when it's dealing with unpopular speech. Speech that if you had a vote and if you had 100 people vote, the speech would lose like 80-20. And so 4 out of 5 people don't like the speech. A strong majority of the people don't like the speech. Well, that's when you need the protections, because there's this kind of minimum baseline right that you have for free speech, and shouldn't go below that line, even if it is unpopular. So this is a little bit analogous to that, having the right person assert these rights. Um, you, again, in this context of Fourth Amendment, a reasonable search and seizure, see that we don't have the best role model of a plaintiff, and that is when the legal principle is supposed to apply the strongest, because it is setting that boundary, it is setting that floor, and it is being tested and seeing if it will bend or break. And often that is when there is a reminder that there is a real floor and we need to not cross that barrier. As I said, Daniel Retz, he wasn't a clean shaven, successful business owner and public servant or something like that. He was basically unsympathetic and angry and irritated, using profanity, causing somewhat of a scene, and that could potentially dissuade the jury from voting for you. But still, though, the jury can consider that, and they can react to different things and ask themselves, okay, let's look at this person. Let's look at their body language. Are they being consistent? Do they seem like they're just telling it like it is, or are they constantly thinking how to frame things, how to respond to questions and slant their answers? Or is it just coming out like it happened? And that's more important than, in this type of case, that's more important than being likable. Likability is extremely important most of the time. And maybe it is in this case too, but it's not supposed to be. It's supposed to be about this standard that I keep talking about. It protects the most irritated, angry, annoying of us, as well as the serene, patient, etc., as long as it's not below the floor. So let's see. Chapter 4, contempt of cop and professional restraint. So there is this phrase, contempt of cop, and you can almost put it down as a category of potentially excessive force claims, but it's people getting in trouble for mouthing off and not listening when otherwise whatever they were doing wouldn't really be illegal. Though their true crime is they challenge the authority, but and have to pay consequences for challenging mere authority, not any other real legal violation. It's a thing that's been studied, and it's definitely comes up again and again in these Fourth Amendment claims. Sometimes maybe it's legit, sometimes maybe it's not legit. But this case does have aspects of what's known as contempt of cop. If the officer is embarrassed, the officer may take that out. If they feel entitled, they may not like that, and they may feel like they need to change that. So that just is a punishment for the sake of punishment, and it's not really the role. It's not the proper role. Although I'm not an officer, and I can't really say like what it would be like to have to enforce some of this, but I'm just talking about it from the Fourth Amendment perspective. This is how it's broken down. Is there definitely are. So the Fourth Amendment is I would say it probably doesn't provide that much protection, at least what it was normally thought of as one of the stronger amendments, especially for your house. That's when it's like the strongest, but there's so many exceptions. And public safety is going to be an exception in a bunch of scenarios. So that's where the officer is going to be able to justify what they did. Like there are a lot of exceptions that do allow the officers to do what they need to do. And that's why this is such a rare case, is because it thread the needle in a situation where the boundary was crossed and there wasn't really a public safety reason to do this. The difference between cuffing someone in the back versus cuffing them in the front. When he was already patted down, you already have other officers on scene, and the girlfriend's already in the car. And what Retz did was rude and annoying, but probably nothing would have happened if he just kept on walking. It would have been pretty much over. But the officer arrested him, and I think we might get into it, but I think he thought that Retz was saying that to him and flipping him off. But what Retz said was he did that to his ex-girlfriend. Okay. I'll talk a little bit about this test. It's objective reasonableness from the perspective of a reasonable officer on the scene. And this, it's a lot of words there, but you're supposed to basically look at everything that was going on, known as the totality of the circumstances. And then one of the key parts to the analysis is the time of events that you consider. Their hindsight is supposed to be off limits. It's supposed to be not part of the analysis at all. Anything that someone could have done better had they known XYZ in hindsight is not part of the test. So that's one thing that protects good faith mistakes, and it essentially explains what you mean by a reasonable officer. It's what they know at that time before they asserted the force. And that way, there is a lot of immunity. That's kind of one of the miracles of this case, is that it survived qualified immunity, because the reasonable officer there, that is what we want. We want a reasonable officer, and the law protects a reasonable officer. And that's why so many of these cases get dismissed, even if there were mistakes, even if it was borderline poor work or actual just things did not play out how you would have liked. But it's evaluated moment by moment. And it's not about negligence. It's not about mistakes. Usually, it's like I said, it comes down to the officer. If you accepted that he knew Retz had a injury to his shoulder and therefore could not cuff his arms behind his back, then that is basically the case. Should the officer have proceeded to cuff him behind his back at that point, or not cuff him, or cuff him in the front, or cuff one arm or something? That is basically the case. And it's not, oh, shoot, I didn't know that. You didn't tell me that. I wish you would have told me that. It was an accident. It wasn't like that. It was more he said versus he said. And whether the Constitution protects Retz in that situation. Chapter 5, this is the bullet time analysis. And Fourth Amendment law, for you to get it and understand it, you have to slow things down, like a movie in slow motion. Let me think of some of the best slow motion scenes while I take a drink. Definitely The Matrix. slow motion. Like, I don't know. I'm thinking like Last of the Mohicans in the last scene when Uncas, the younger Mohican, and I think he might be the last Mohican in the story, or he is killed by Mogwai on the side of the mountain. And it's very dramatic and sad. And Chingachgook sees this from afar and sees his son die and fall offside the mountain. And so he runs to kill Mogwai. And Mogwai is pretty confident, but Chingachgook is an OG Mohican. And so he hits them with the duck under, spin move, axe to the back, KO, dead. And I don't know if that was in slow motion, but that's kind of how I think about it. Let's see, are there other good slow motion examples? Well, I mean, if you played Max Payne, it's the same thing as The Matrix. Max Payne had actual bullet time. It was really fun. I played probably like 3 different Max Payne games that were awesome. I even thought the movie wasn't that bad. Silence of the Lambs is at the very end, slow motion in the night vision goggles, where they do there's an amazing cut at the end of Silence of the Lambs, because you think it's like, you think that is this the same cut? I think that you think that they're at one house and the police are arriving at the Buffalo Bill's house, but then they cut to Jodie Foster, and she answers the door by herself, and so she's about to walk into Buffalo Bill's house by herself in like the murder dungeon in the cave thing, in the well, and the power goes out and she's by herself, and then you see the night vision goggles and she hears something. Maybe he like stepped on a stick or something, I don't know, but I'm pretty sure in slow motion she does like a dive, reverse, bang, bullet time, and gets Buffalo Bill. So think about that. That's pretty much Fourth Amendment law. You got to watch those movies. But here's really the lesson I'm kind of trying to tell you is you got to slow this stuff down. At normal speed, it's too chaotic. You could not notice things. You could focus on the wrong thing. You could miss details that make all the difference. People are yelling and screaming. Things are moving fast. There's an officer saying different orders and wants compliance. Let's say there's resistance. Maybe there's resistance force. Now you have physical encounter. Officer grabs somebody's arm, puts him on the ground. So that type of situation, you think, hey, makes sense. I mean, it was happening fast. Officer had to step in and they resisted, so put him on the ground. That pretty much would follow, I think. Not adding stuff. You could add to it and change the result. You could have the same facts, but you could say the person was already patted down. They were about 50 pounds lighter than the officer. It was a littering crime, and they had already said they're sorry and wouldn't do it again, or something dumb like that. And that could change the analysis, because if you notice what I did there, I made the stakes so low that you don't really need force. A reasonable average officer wouldn't need to grab someone and take them down to the ground when it's such a minimal thing and there was really no threat and things were getting diffused. That's sort of how you think about it. So here's some more pieces to the analysis, and we'll try to apply them in this case. Think about your reasonable average officer, and then you start adding facts, and it's usually the officer's facts before the force is applied, the totality of the circumstances, what do they know, and what is their training and experience also can be sometimes relevant. So sometimes when you say a reasonable officer, you could say, if this officer had 20 years of experience, I think you could say a reasonable officer with 20 years of experience, because I do think that matters. There's all kinds of training on these situations. And so that's part of what they know before. It's not hindsight. So they are prepared for things like this, and they're supposed to know what the playbook is. And so that can be part of it, the training and experience. But, what are they seeing? What are they hearing? Is there any threat? Is control established or not? Are there alternatives? Are there more or less forceful yet safe alternatives? So here is another hypothetical at normal speed. So imagine this, and remember, you're trying to apply this Fourth Amendment analysis. So an officer grabs a gun. Oops. Start over. An officer grabs a man, forces his arm behind his back, and takes him to the ground. That's an arrest, and it's an ordinary arrest. The guy can be handcuffed, but then let's change it again. It's 2:45 a.m. in the morning in a parking lot. There's lighting. There's visibility. It's generally safe. There's no immediate apparent threats. There's 3 officers, 1 civilian, 3-to-1 civilian ratio. The civilian's been patted down. The civilian has no weapon. The offense is not assault. It's not a violent offense. It's not a gun offense. It's not a fleeing police offense. It is disorderly conduct, which is profane words and an F-U gesture. So I mentioned the Graham case. This is the reasonable officer test that we're going through. And think about this in terms of contempt of cop. Maybe there is no threat and there is a 3-to-1 officer to civilian ratio, but the civilian is being a little too cute. He's not submitting. He's angry. He's mad. He's not smiling. He's not calm. He's kind of not under control. He's agitated, but he's not a immediate safety threat. He's annoying. He's not listening. He's being a jerk. And then if he says, I can't put my arm behind my back, I just had shoulder surgery. That knowledge is so important in this analysis that it could, if you believe Retz, you're going to pretty much vote for him. If you don't believe him, then he's going to get squashed big time. That fact is so key. I can't put my arm behind my back. I just had shoulder surgery. It's not hindsight. If you believe Retz, it's not something learned after the fact. It's part of the bullet time analysis. And the officer still had a choice. Do you ask, what do you mean you have had shoulder surgery, or look at his shoulder, or test it a little, just tug on it a little bit? Do you say, don't move your shoulder, I'll cuff you in the front? Do you say, hey, officer, Johnson, help me. What do you do versus other than cuffing him in the back and allegedly saying, I'll show you how far back it will go? It doesn't, the officer isn't supposed to be perfect. And what if there was an injury, but it was an accident? And what if it could have changed if they said, yeah, I knew there was an injury, but I tried to do it better and it didn't work. I don't know. That could be maybe a different story. But under these facts, it was the claim was contempt of cop, showing him who's boss, applying force that's more than necessary and causing injury, knowing that there was a prior surgery and a weakness. So was that necessary? And it depends on who you believe, but that's how you look at it. So let's see. I'm trying to make a decision of whether I get into the Kyle Rittenhouse case, because it really is this exact issue. I watched the Runkle video on this, and it was really good. Runkle said that this was one of his favorite examinations within the last few years. And I'm not an expert on this case. I know when I first read about it, I was annoyed by it because Rittenhouse was so young. That was part of what annoyed me, is he seemed nuts to me. But whatever. That was my impression, and I didn't really follow it that close. I'm not really that interested in it that much, honestly. But this issue is Fourth Amendment use of force, and it was between two citizens, but it is still a perfect example of what we're talking about. So I watched Runkle's video on this, and he said the cross of the man who was shot, I think it was in the arm, and he was like some kind of political activist on the scene. And he was a plaintiff, I think, or he was the victim, and maybe this is a criminal case. And I think part of the cross was that he was going to be a plaintiff in a assault case against Rittenhouse and asking for $100 million or something. But I will admit I probably was biased against Rittenhouse. He's just such a stupid look on his face. I just want to smack him. Sorry, he's like a little rascal, and I'm just annoyed by that. But that could be my own imperfections and whatever. I don't know him, and I don't really need to make this point. But if you watch that cross that Runkle's talking about, I guess there was an exchange of gunfire, and the attorney pretty much proved on cross, when you slow down the video, the other guy is pointing a gun right at Rittenhouse, and you pretty much can see it. And the only reason I know this is because I watched Runkle's video, but I think I was persuaded by what Runkle was saying, is if you slow down and look at that and think, what is the rule if someone points a gun at me? Is that a threat to my life? Became pretty, the case is kind of over at that point. And then also the prosecution was kind of weird, how, I don't know, I think it maybe was a political prosecution, at least parts of it. I wasn't really a Rittenhouse fan, but the prosecution kind of was sucking it, I think. And that really, after you watch the video, and it's insane, there's different crazy stuff happening, and I think they said that Rittenhouse had been like kicked in the face or something. And then the guy who got shot runs up and points a gun at him. So that is a slow motion, bullet time, moment by moment analysis. And feel free to disagree. I'm do not care at all if you say I'm wrong and you want to talk about this more. I could be missing something, but it seemed to me that that is a pretty applicable example of if you actually do slow it down too. Is the thing is it's such super chaos, like out of control nuts. But it's certainly an example of a couple of seconds make a difference between life and death. I think that was a really strong example of slowing things down. And although it didn't involve police officers, it's a similar idea to using force when necessary, and also maybe the similar idea of having the same rule applied to even people you don't like. I think it fits well. So, okay, let's get back to the Retz versus Seaton case. This is when we're kind of building the record. There's discovery happening. And so this is chapter 6, internal affairs, depositions, building the record. And I was working on this case during law school. A lot of document review, building timelines, comparing interviews, looking for inconsistencies, and trying to line everything up with this moment by moment analysis and slowing things down. I reviewed the internal affairs interviews line by line, and we used that to prepare depot questions. There's 3 officers on scene, and we kind of try to litigate that bullet time and figure out what facts are happening all at the time. And so try to diagram the scene. Okay, where was the police cruiser? Where was Retz? Where was Kofel? Who knew that, or who could see the manner of cuffing in the front and the back? Who were the witnesses? Who overheard the exchange between Retz and Seaton? Did anyone else hear about the surgery warning? Who knew about the surgery injury? He'd been patted down before. Was there any mention of that? Under the different officers who were there, in their opinions, was the situation under control, or did it need to get under control? Was there different kinds of resistance? Was it affirmative resistance? Was it defensive resistance? What was it? Physical? Was it verbal? Was it emotional? Was it physical? Did I just say that? Did anyone see? Because after the next thing that happened after Seaton cuffed Retz in the back is they basically fell to the ground in some like watery, nasty parking lot stuff. So who saw that? What did they say about it? That's what makes it better than he said is facts like this and witnesses who weren't involved in the one-on-one encounter but can fill in the tapestry and landscape for our analysis. Let's see. There's no video. It basically came down to did they believe Seaton? And I do think he had a bad demeanor on the stand. He definitely fit the profile of this contempt of cop type thing. I think that came out a couple times on cross when he's asked some clever questions, and then he would get a little bit red and mad and kind of puff up. And even though he had his glasses on and looked clean cut, he did show flashes of that. You better listen to me or I'll get mad type of behavior. Chapter 7, this is kind of a interesting local note for the United States District Court for the District of Nebraska. This trial, this jury trial, I guess it was my first trial. although I did mock trial, but this is my first real trial, and a jury trial is a totally different beast than a bench trial. And I've had more bench trials than jury trials. Jury trials are pretty cool, but there's a lot. So there's so much happening. Really, it takes time for the lawyers to get this bullet time. Um, and sometimes they talk about in sports, you need things to slow things down for you. You need that experience so you can react to things in time. And in trial, there is so much happening because the lawyers are trying to pay attention to everyone and put on a presentation of their case, persuade everyone, gain credibility, don't lose credibility, and get the train to the station on time. But we were lucky because we had a great judge, Judge Lori Smithcamp. She was a prominent Nebraska federal judge. She's deceased, rest in peace. She served on a federal bench for many years, and she was the chief judge of Nebraska, the District of Nebraska. That's a federal court in Nebraska. She graduated from the same law school that I did, University of Nebraska College of Law, and her memory is honored through the Lori Smithcamp Legal Scholar Fund. I was the second chair. I was the second eyes and ears, and I helped with voir dire, helped pick the jury, watch them, helped prepare the examinations based on the investigation of internal affairs reports and our depositions, and helped with themes. We also, in jury instructions, we had our jury instruction conference. We met back in the judge's chambers, and one thing that I thought was cool was she had a copy of To Kill a Mockingbird. There's some kind of rare, like, old copy that was signed. I don't know exactly what it was, but that's a really neat book and story. And let's see. I guess one thing we did have to overcome is having a plaintiff that's not likable, and that sometimes you even hear the lawyers say that, like, to a jury, you don't have to like this client. I don't even like him, or something like that. And sometimes that can carry the point, but that's not what you would prefer. You would prefer to like them. But again, it kind of fits our theme. Is if you don't like them, that's fine, and you acknowledge it and say it is what it is, but it's not the test, and it doesn't matter. And the fact that you don't like them, it should remind you of what the rule is and is not. Let's see. How did the jury decide? There was a lot of evidence about specific statements, and we were able to show that the two other officers were, like, right next to this, about 5 to 10 feet away. And they didn't really, the claim wasn't really against them, but it was just to show that the scene was under control, and that probably this happened because Officer Seaton thought that Retz flipped him off and said "F you," but he actually said that to his ex-girlfriend who had just stolen his car. And then I think that is kind of what was proven. The problem is the plaintiff carries the burden of proof. We can't just tie. We have to prove at least 51% that this is how it worked. And if we don't get you there on all of our elements, essentially everything has to add up, and for everything that's required, we have to get you over that hump to believe us more than you believe them. It's a game of comparison. And if it's a tie, we lose. So all of these, we had to be very fact specific and make sure there's no holes in what we're saying and build that bullet time landscape. Chapter 9, the verdict. Damages. It's not like it was a huge amount of damages, but we did win. Really, what was huge was the principle. So, after a 3-day trial, the jury found in favor of Daniel Retz and against Omaha Police Officer William Seaton, and the jury awarded Mr. Retz $31,505.23, which was pretty much his medical bills and surgery. Maybe it could have been more, but I think that Retz was not going to be able to get more than that, basically. They gave him something, and it sends the signal that they believed him and did think his rights were violated to the tune of $31,505, but it wasn't more than that. They weren't willing to go with him further than that. We had requested more for pain and suffering and punitive damages, but they weren't willing to go with that. It was pretty disciplined and specific to saying, this officer destroyed your surgery and we're going to give you money for that. They basically said, yes, the officer did cross the line. Maybe you were kind of played a part in that. But that makes the verdict more credible than one that would have awarded $1 million. They show that they got what was going on. They didn't accept everything that we were saying. They agreed with our basic claims, but just not the full extent of maybe what it could have potentially been worth. But they did agree that there was a Fourth Amendment violation and that there is still this floor that we're talking about, and that a jerk citizen still has a constitutional right not to be subjected to unreasonable or excessive force. Here's the other amazing part about this case. It was appealed by the Omaha Police Department, to the 8th Circuit. So it's a federal court, and the 8th Circuit affirmed. They said that the district court, Lori Smith Camp, did not abuse her discretion in her different rulings at trial. And one of the arguments the defense made is the Constitution doesn't require police to do the best possible result, which is true. But when deciding when force is objectively reasonable, you can consider a range of choices available to the officer at the time. That's exactly the bullet time framework. The officers are not required to pick the best possible alternative, but this is relevant to deciding whether force is reasonable under the circumstances. And that's the balance. There is no using hindsight. There is simply a standard for reasonableness. So this is what I call the 1 in a million type odds, because again, I remember the Darrell Parker case, pretty rare, right? 56 years of justice, or of time it took to get a wrongful conviction corrected. Sounds like a rare case, pretty rare in Nebraska, and this one is super rare also. I don't know for a fact that it's 1 in a million, but I tried to think of some different ways to show quantitative measures. So chapter 11 is kind of about why this is a against the odds result. According to the Bureau of Justice Statistics, the percentage of civil rights cases conducted by trial won about a third of the time, or less than a third of the time on average. This says from 2000 to 2006. This is super random. I hope this means something. I'm just reading some stats. I hope this will deliver the point. Really hoping. It said that the Bureau of Justice Statistics reported that federal civil rights plaintiffs won under a third of the time on average from 2000 to 2006. So only a small percentage of these cases even reach trial because they get dismissed a lot. Of those that do reach trial, the plaintiff wins less than a third. Then there's the appeal, which could filter out even more cases. So there's definitely a legal asteroid field here that is a formidable barrier to a plaintiff civil rights claimant's success. It might be 1% and 1%. If you can find stats, let me know. But from a quantitative or from a qualitative perspective, you could say it like this. We had a civil rights case where the plaintiff was not likable. He's pretty close to being a homeless vagrant, living in a car, and there's evidence of drug use. Has a civil rights claim against a Omaha police officer, is able to win at trial and survive the appeal and not have a new trial or have the result reversed. So think about all those odds, multiply them together. I think it's probably at least 1 in 100,000, but probably more like 1 in a million. I don't know. Maybe it's not 100, or maybe it's not 1 in a million because you have to find a million cases like this. But if you apply it broadly enough to find like qualified immunity cases that go to trial, the plaintiff wins, and the result isn't reversed, it's got to be pretty unlikely. Okay, let's see. We'll have a little closing monologue. The whole thing was a monologue, so my opening and middle was a monologue, but now for a closing monologue. So this, the constitutional floor. Daniel Retz did not win because he was perfect. He wasn't perfect. He didn't handle the night very well. He actually had kind of a he had an uncomposed direct examination. I do remember he was examined by the city defense attorney who told us to go back to Lincoln or something like that. And there was a moment in Cross where that attorney definitely was getting under Mr. Retz's skin a lot, and it caused him to freak out and make emotional accusations. And he said something like, Daniel Retz said something like, "I'm trying to not say what I think about you right now." So putting his foot in his mouth. But it didn't really make that much of a difference. It's just memorable that it happened like that, and that you're not going to have the best plaintiff, and they might not be a good advocate for themselves. But in this situation, again, it doesn't really change the claim that much. The claim is bullet time, slow motion, Should the officer have cuffed him in the back or not? And if you don't like the plaintiff, it's not the test. So that point is just hammered over and over and over again. And it requires patience. It requires open mindedness. It requires discipline to this doctrine about the reasonable officer, being able to give the officer the benefit of the doubt in most situations by far, but still recognizing that there's a line, there's training about this, and there's constitutional rights about this. Let's see. So these are some of our constitutional commitments. The government's not supposed to apply unreasonable force to citizens just completely unfettered or unlimited way. It's supposed to apply boundaries in a neutral way that respects human decency. And that's what this federal jury said in Omaha, and the Eighth Circuit allowed it to stand. That's why Retz versus Seaton matters. The Daryl Parker case taught me about how long the truth can be buried before it comes to the sun. And the Retz case taught me how truth gets built in the moment and requires slowing things down, looking at all the circumstances, frame by frame, question by question, witness by witness, until the chaos slows down for the law to see what happened. Thank you. I don't know if I had anyone. Oh, wait, I had 2 likes. Yeah. I think that's all I got, but I hope you have a great Sunday. I'm not sure what my next one will be. Why don't you all tell me what you want to do? I have probably a whole bunch. These are 2 of my favorites, though, that I knew I wanted to do. And I might do like a dog one, or I don't know. I should probably do some kind of like thing where I give everyone an update, because originally my channel was called Peace in America. Now it's called New Joel. I'm doing different stuff, but I'm also the same guy doing the same stuff in creative ways. I'm all about edutainment. I like to bring in my dog. I like comedy, law, music, and basketball, sports, baseball. I'm learning golf. Golf was extremely hard, but I'm going to try to learn it. Then I have different videos that I hope you like. The VHS workout videos from the 80s and 90s. I have some golf tip videos. I have tons of NBA games. I hope you all watch that. I have tons of Michael Jordan games. I got all the great Michael Jordan Bulls games, and I got some Wizards games. And I'm going to pretty much find all the videos I can and put them all out there. And once I've done that, then I'll move on to other stuff. Maybe I'll do a little bit of baseball. I might go back in time and do like the old basketball, like 80s and 70s or 60s maybe. But that's the type of content. But tell me what you want to see. I'll try to figure out the next true crime type of case. I think I can. I got a million of them, but these are 2 of my favorites. So tell me what you want to see. I will sing for money. I like Bruno Mars. And I want you to love, dream, smile, and increase the peace.